My name is Banan Abdurrahman, and I'm a PhD student in the anthropology department. It's a great pleasure for me to introduce our speaker, Professor Leti Volpp from the UC Berkeley Law School, who will be speaking to us about how to imagine abolition in the US immigration law context. This topic is especially timely as the Biden administration is thinking of reestablishing a new asylum ban, bringing back family detention centers that were prominent in both President Obama's and President Trump's time, and returning to pre-COVID detention numbers. Currently, ICE detains about 30,000 people, and the numbers are steadily climbing every day. Today, we understand that abolition in the immigration law context works to end immigration detention, enforcement, and deportation, explicitly understanding immigrant justice as part of a larger racial justice fight connected to the cruel history which fuels our incarceration system, namely white supremacy. It is with this spirit that Professor Leti Volpp, as a scholar of immigration law and citizenship theory, writes. Her work examines how the law is shaped by culture and identity, and how otherness is shaped and reshaped in the US legal system. The range of topics she's written on include how can we understand the coffin migrants running signs, road signs scattered across highways along the US-Mexico border as stand-ins for the signs of law, signifying persons who have been rendered outside the law. So how can we account for the shifting understanding of citizenship? As she writes 20 years ago in The Citizen and the Terrorist, after the September 11 attacks, unleashed a surge of anti-Muslim, anti-Arab, and anti-Middle Eastern rage, saying she aims to provoke a rethinking of what bodies are centered in our consideration of citizenship and what bodies disappear. Who is the us in the US? This provocation is the thread with which much of her work is built on, and urging to question how the law categorizes people who move across borders, rewarding only some with particular rights and recognition. This questioning has produced a wealth of diverse knowledge, which is reflected in the various positions she holds. Alongside being a law professor, she also is the director of the Center for Race and Gender and holds several affiliations at the university, some of which include the Center for the Study of Law and Society, the Othering and Belonging Institute, and the Berkeley Interdisciplinary Migration Initiative. And with that, friends, please join me in welcoming Professor Leti Volpp.
Wow. Oh, I was so excited to see that Banan was going to do my introduction. I want to thank Kubarti for the invitation, Patty, Victoria, and Bex for this amazing event, all the organizing. And I'm just so excited to be here as part of CC's inaugural symposium and to be in this room with you all. So what I'm going to talk about is what does abolition mean in the US immigration context, examining both legal scholarship and immigrant activism in the United States makes palpable a schism between more frequent calls to abolish US Immigration and Customs Enforcement, or ICE, and far more muted calls to end border control. Why has advocacy for abolition of immigration enforcement in the United States appeared to veer away from border enforcement? What I want to do in this talk is survey how abolition has surfaced in this context to show this prioritization of abolition of ICE, or synonymously abolition of deportation, with a secondary prioritization of abolition of immigration detention. We see this prioritization alongside a relative lack of prominence of call for the abolition of border enforcement, not to mention a paucity of calls for the abolition of borders altogether. This appears especially curious as the context in which the call to abolish ICE exploded in 2018 was the Trump administration family separation policy, which was conducted not by ICE, but by Customs and Border Protection, which controls immigration enforcement on the border. Was this an issue of effective slogans, a legacy of previous social movement strategies, or a reflection of philosophical choices about immigration and borders? I look forward to collectively thinking through these questions in the discussion. So the explosion of calls for abolition on the US national scene about abolish ICE in the summer of 2018 had been preceded for several years by immigrant activism. So if you think back a decade or more, in March 2010, taking a page from Harvey Milk, undocumented youth started coming out as undocumented and unafraid, and subsequently also as unashamed and or unapologetic, and efforts to propel the passage of the DREAM Act, which, if it were ever to pass, would create conditional permanent residency, meaning people would be conditional residents, and after 2 years of qualifying, conduct, which could be either graduating from or attending 2 years of university or 2 years of military service without a dishonorable discharge, could become permanent residents. In December 2010, the closest the DREAM Act ever came to passage was it passed the House, but died via a filibuster by the Republican Party in the Senate. By mid-2011, youth activists regrouped and began to press for relief from deportation for youth brought to the US as children. Seeing how discretion operated in the immigration system with choices made about which cases to pursue and which to drop, and the importance of public pressure in shaping these decisions, youth activists began to press then President Obama for categorical relief from deportation for so-called dreamers. In June, the Obama administration announced the creation of DACA, which rather than granting conditional permanent residency for those who qualify, essentially functions as a promise of prosecutorial discretion. We won't remove you for a period of 3 or 2 years. DACA does not create lawful status, and it does not turn into lawful status. President Obama was then re-elected after he announced this program in November 2012, with pundits crediting what was called the sleeping giant, close quote, of the Latinx electorate. So President Obama then promised to take up immigration reform in his second term. The Obama administration was also engaged in an escalation of immigration enforcement, as in my colleague Kathy Abrams's words, a down payment on bipartisan collaboration on immigration reform. You can see here this enforcement reaching unprecedented levels, which led to Obama being named the deporter-in-chief. I just need to note, you can see how they divide this into criminals and non-criminals. Obama had famously said in 2014, he wanted to deport felons, not families, as if felons don't have families. This grotesque kind of splitting of deservingness that must be repudiated. I also want to make clear what is meant here by criminals. If you look at this slice from that year, this pie chart from 2013, over 30% of people being deported as, quote, criminals, their crime is an immigration violation, essentially border entry or border reentry. In response to these deportations in 2013, the Not One More campaign began, starting as a project at the National Day Labor Organizing Network. I'm going to see if I can show you this slide. One of the things, this is their launch, one of the things I think is really interesting is that it was an explicit call to artists. And you can see here the work that Shepard Fairey had created.
Mi nombre es Juan Romero y soy jornalero.
My name is Catherine and I am a student.
Mi nombre es Juan José Morganti y soy jornalero. My name is Angel, I'm a student and I'm a DACA recipient.
My name is Leti and my mom.
So yeah, it's not whatever that, it's fine. It's right. We'll not worry about shining, but there's a link. So it's essentially their inaugural video. And you see a succession of people speaking in English and in Spanish, identifying themselves, explaining how deportation is affecting their lives, and calling for a moratorium on deportation. And specifically making a call to what they call artists of conscience. Not One More featured a new cascade of tactics: disruptive civil disobedience, physically intervening in deportations, hunger striking. Again, my colleague Kathy Abrams's new book called Open Hand, Closed Fist, where she talks about this, and practices of bodily mortification, right? So extreme physical efforts in terms of essentially like pilgrimages to particular sites. And here we see 7 people who basically handcuffed themselves in front of the White House. So Not One More was the foundation for the formation of Mi Gente, which is a grassroots organizing hub, which reflected on the creation of Not One More, saying that it was at its heart an abolitionist call to action in its mandate to shrink mass incarceration systems, to dismantle government agencies that exist solely to bring terror, harm, and violence to communities of color, and to design a movement around those discarded as criminalized. In making the case that Not One More was essentially an abolitionist movement and the precursor to abolish ICE, Tania Unzueta, Maru Mora Villalpando, and Angelica Chavero assert that the idea of a moratorium on deportations can be understood as at the heart, an idea at the heart of the notion that ICE should be abolished. Undocumented members of another organization called the National Immigrant Youth Alliance, and also in 2013, had begun infiltrating detention centers with the idea of organizing prisoners inside and obtaining information so that activists could work on their cases, identify those who were eligible for relief, and generate media attention. That year, that group organized a group known as the Dream Nine, who began the Bring Them Home campaign to draw attention to the Obama administration's refusal to issue a moratorium on deportations. 3 of the Dream Nine, who were all undocumented, voluntarily left the United States to take part in this action to Mexico and then seeking admission. The other 6 had all been deported previously or had left the United States on their own accord. The 9 approached the US border from Nogales, Mexico, watched live by 10,000 viewers as supporters on the US side shouted, "Bring them home." All 9 requested humanitarian parole and asylum and were placed in immigration detention, where they then staged a hunger strike. This was followed by the Dream 30, who presented themselves at the Laredo port of entry wearing graduation caps and gowns, chanting "undocumented and unafraid," and similarly requesting humanitarian parole and asylum. Writing in 2016, Allegra McLeod described the Dream 9 and Dream 30 actions as invoking an ethic of, quote, positive abolition in the immigration reform context. Here drawing on Dubois, abolition meaning not just a negative project of eliminating slavery, but also a positive project of building a new form of coexistence. So here a positive project of abolition in the immigration context through articulating a right to freedom of movement, including a right to remain that would, quote, tether immigration regulation to economic development and other measures to address human needs rather than restrictions, border enforcement. We could note here that immigration regulation that is not restrictionist, but still tethered to mandates such as economic development may not fit the description of abolition. The following year, explicitly building on McLeod's scholarship in the prison context, Cesar Cuauhtémoc Garcia Hernandez called for the abolition of immigration imprisonment in the United States to, quote, gradually replace secure facilities and surveillance technologies with an alternative moral framing of migrants and migration that renders practices of control indefensible. Arguing that the violence at the heart of confinement and its role as a means of agency coordination will not end by attempting to dismantle prison walls alone, Garcia Hernandez called for attention to the United States as an active participant in migratory patterns and to the artificiality of linking a person's moral worth to both geographic location in relation to an international boundary, as well as to their legal position in relation to immigration law. Also writing in 2017, Daniel Morales asserted we need to understand individual acts of so-called illegal migration as a form of political protest speech, enabling both an immigrant's rights consciousness and campaigns such as Not One More. In making this claim, Morales asks us to question the moral and legal foundation of the law that made the act of human movement illegal and suggests that this movement itself gives the idea of open borders life, implicitly suggesting that migration without permission is producing an abolitionist project through defiant actions declaring the illegitimacy of immigration law. The next year, the call for abolition in the immigration context burst into public view in response to the Trump administration's policy of family separations. In May 2018, the administration implemented a new zero tolerance policy, which mandated the criminal prosecution and imprisonment of all immigrants entering the United States without inspection, designed both to discourage illegalized migration and to reduce processing of asylum claims. Under the zero tolerance policy, all adult non-citizens apprehended entering without inspection were criminally prosecuted without any exceptions for persons seeking asylum or who were traveling with minor children. This criminal prosecution was accompanied by detention in federal criminal facilities where children, due to a court order known as the Flores Settlement Agreement, were not permitted to be imprisoned. With parents in criminal custody, children were classified as unaccompanied alien children and transferred to the custody of the Department of Health and Human Services Office of Refugee Resettlement, which placed them in shelters until they were released to a family member, guardian, or foster family. During the 6 weeks in 2018, the policy was officially active. DHS separated 2,816 children from their parents for guardians. Under litigation pressure, the Department of Justice disclosed the separations of an additional 1,556 children during the Trump administration that actually predated the official policy of zero tolerance, as well as the separation of an additional 1,000 children subsequent to the purported end of the policy. And these, as you know, these separations were conducted with no tracking or reunification system. And as of February 2023, an estimated nearly 1,000 children have still not been located in relationship to their families. On June 18th, 2018, a horrified public heard an 8-minute secretly recorded audio tape of sobbing children crying for their parents in a Customs and Border Protection detention facility. And the cover of Time magazine in June 21st, 2018 featured the superimposition of a photo of a 2-year-old girl who was crying, reacting to her mother's detention by a border agent in Texas with a depiction of Trump and the text, "Welcome to America." So family separation was conducted by Customs and Border Control, which controls immigration enforcement on the border. If referred for criminal prosecution, individuals are placed by CBP in the custody of the U.S. Marshals Service and transported to DOJ criminal detention facilities for pretrial detention. Only after being tried and if convicted after serving a criminal sentence would an individual be transferred to ICE custody and put in immigration detention for removal proceedings. Yet, as we know, the response to family separation was to call to abolish ICE. The hashtag abolish ICE was apparently originated by this person, Sean McElwee, who was recently fired from the polling firm he co-founded Data for Progress. He's a close associate of Sam Bankman-Fried, who I'm sure you're familiar with, and had originated this hashtag in 2017. So family separation becomes public, hundreds of protesters take to the streets, hundreds arrested after a women's protest in the Hart Senate office building shouting "Abolish ICE" and "We care" in response to Melania Trump's jacket that had stated, "I really don't care, do you?" on her trip to visit children in an immigration detention facility in Texas on June 21st. Alexandrina Ocasio-Cortez's cries upset victory in a primary challenge on June 26th, after putting calls to abolish ICE at the center of her platform, led other Democrats to do the same, including New York City Mayor Bill de Blasio and Senators Kirsten Gillibrand and Elizabeth Warren. On July 4th, Teresa Patricia Okumo climbed the Statue of Liberty with signs held by other protesters to abolish ICE and was subsequently arrested and prosecuted for trespass. Facing up to 18 months in prison, she ended up getting sentenced to 200 hours of community service and was put on probation for 5 years. Writing in The Nation in July, Julia King asserted that Trump's, quote, practice of tearing children from their parents has woken up the country like little else in either Trump's extreme anti-immigrant agenda or in Barack Obama's record-setting deportation spree. We could thus contemplate how, as with the death of Alan Kurdi, the figure of the vulnerable child galvanized reaction for observers who could not imagine themselves trying to cross a border, but could imagine losing or being separated from a child. The sudden engagement in calls to abolish ICE thus being triggered not by any commitment to questioning immigration control, but by the reaction of horror to the vision of the Trump administration and to the horror of seeing separating, screaming and sobbing children. In July, Representatives Mark Pocan, Pramila Jayapal, and Abhiano Asfayat introduced legislation to, quote, abolish ICE through the Establishing a Humane Immigration Enforcement System Act, which would eliminate ICE within 1 year of enactment after setting up a commission to examine alternatives and transferring essential immigration enforcement functions to existing federal agencies prior to the termination of ICE. This seemed similar to the tweets of Bernie Sanders, who followed, quote, now is the time to do what Americans overwhelmingly want, abolish the cruel, dysfunctional immigration system we have today and pass comprehensive immigration reform with the message, quote, that will mean restructuring the agencies that enforce our immigration laws, including ICE. So to these politicians, abolish ICE does not mean abolish immigration enforcement. We see this also with this tweet from Alexandrina Ocasio-Cortez clarifying that abolishing ICE does not mean abolishing deportation. So much concern seems specific to the dysfunction of ICE as an agency rather than about the fact of immigration enforcement. A creature in September 11th terrorist attacks, ICE was located alongside Customs and Border Control within this new Department of Homeland Security. The service functions that used to be combined with enforcement in the former Immigration Naturalization Service, or INS, which had been housed in the Department of Justice, were shifted to a separate agency called USCIS, or Citizenship and Immigration Service, severing service from enforcement. ICE and CBP were contained within the broader rubric of the Department of Homeland Security's focus on counterterrorism, securitization, and defense of the homeland, with immigration enforcement nestled within this broader mandate. The notion of abolition of ICE succeeded by continued immigration enforcement ends up getting replicated in some legal scholarship, as you can see here, an essay by Peter Markowitz that calls for a vision of a new immigration enforcement paradigm that is humane and effective, but that does not rely on the existence of ICE. He clarifies that by enforcement, he's using the term to describe any method to address compliance or to encourage compliance. To give you a sense of this argument, he calls for what he calls optimal enforcement scaling, which is modeled after the IRS, so that there's like a kind of panopticon surveillance of everybody, but only a few people get audited or penalized. This is clearly very far away from what abolition means in the sense of reconstruction and envisioning a world anew. Here, abolition means only to end something and replace it with something that is still accomplishing similar purposes, a surveilled population vulnerable to deportation, which is a classic reformist reform. And another article, Kari Hung opts for what she calls a middle ground to the calls to abolish ICE, pointing out that ICE consists of two agencies, Homeland Security Investigations, which is the investigative arm of ICE, and investigates transnational criminal matters, and enforcement and removal operations, which manages all aspects of the deportation process. So the middle ground that Hong seeks to occupy is defunding ERO while maintaining HSI agencies, stopping short of ICE abolition. The reasoning why Congress should defund one section and not the other is articulated within these limited logics. For example, ERO is wasteful, it's unnecessary to keep America safe. HSI can do that, right? ERO hurts Americans, it hurts the US economy, et cetera. So not surprisingly, neither Markowitz nor Hong reached the question of abolition in relationship to the border. Other recent immigration law scholarship appears more sensitive to what is intended by abolition. Here, I think there are two interesting pieces focused on immigration lawyering and advocacy. The first one, by Ming Cheer, looks at how, what kinds of immigration-specific demands were made of the state since the advent of the pandemic. First, including undocumented immigrants within COVID-19 relief efforts, and also releasing people from ICE detention centers with the hashtag #FreeTheMall, and argues that standing alone, these are not abolitionist reforms that are transformative, non-reformist, or revolutionary. In terms of COVID-19 relief efforts, she points out these efforts are about inclusion, not transformation. They do not address needs beyond a specific crisis, nor lead people to question the legitimacy of the government. She said that such a call needs to be accompanied by a call for divestment from police, prisons, and other actors of mass incarceration. And in terms of the demand to free them all, she notes that in some places, immigrants' rights groups also simultaneously demanded the release of people from criminal custody. Only when connected to broader decarceral calls are campaigns calling for the release of all people from detention, abolitionist reforms. So while making these astute observations, Cheer also does not address the question of the border. Leila Halas links abolition theory to lawyering practice, calling for a deportation abolition ethic to forward efforts to dismantle immigrant prisons and policing and reimagine a new and just future. And so in thinking about this abolition ethic, she says, lawyers who do this need an anti-racist orientation to directly confront and disrupt anti-Black and criminality narratives in immigration legal systems, which would mean attorneys should not categorically refuse to represent detained clients or those with convictions. They should refuse to rely on racist narratives, even when the lawyer assumes it may assist a case. and they should try to develop practices that build power with immigrant clients and communities, which is a familiar requirement of community-based lawyering. She then undertakes this complex discussion of the pros and cons of what she calls hard cases. So the creation of community bond funds, like there's a rotating bond fund to get out of immigration detention via bond. You actually have to pay the entire amount, and people don't have access to the thousands of dollars this requires. There's a rotating bond fund that moves around. Ending ICE contracts with detention facilities. There's this long campaign to get ICE out of Northern California, which actually succeeded, which means that now people who are picked up in Northern California are sent to these facilities in Southern California near Bakersfield. And it's hard because it's like people are farther from lawyers, further from clients. It's a Bay Area attorneys are representing people in Golden State Annex and Mesa Verde. However, it does seem as if fewer people are put in detention because of this removal of these facilities. And then lastly, this kind of broad question about fighting for universal representation to counsel in removal proceedings. So unlike in the criminal context, because immigration is civil, there's no state-funded counsel. Should every immigrant get a counsel, a lawyer provided by the government, or does it legitimize what is this incredibly unjust system? While Leila Flas cites Taharsha Walia, pivotal thinker on the question of no borders, for an observation about how the racial subordination of enforcement means immigrants are highly vulnerable to labor extraction, the article does not touch the question of border controls. In another helpful essay, Alison Kremen-Dunlap notes that taking literally the call to abolish ICE is virtually meaningless. Given that ICE is but one entity in this system, designed long before ICE to produce mass deportation and detention, what might it mean to abolish ICE? The simplest answer, Kremen-Dunlap notes, is nothing, and points to the bill that was proposed as doing exactly that. But abolition can mean something very different, and here the article uplifts the Free Our Future platform of Mi Gente. Essentially articulates as its central goal abolishing ICE so that immigrant communities can live with dignity, including requiring a moratorium on deportations, ending all forms of immigration detention, repealing all laws, criminalizing migration, and reimagining border patrol with as one possible alternative, a new border rescue group that would function as a humanitarian force that helps migrants. And I know there are issues with humanitarianism as well, but well, it's obviously preferable to the current system. While the platform does not explicitly demand a world without nation-state borders, the Border Patrol will no longer be engaged in policing them. And in the article, Kremen-Dunlap importantly reminds us of ways CBP currently engages in policing. They enforce immigration laws at ports of entry and along the border, including anywhere within 100 miles of the border, which covers actually a lot of the US population, about 2/3. They issue expedited removal orders, which account for almost half of all removals through a summary form of exclusion. And like ICE, they also incarcerate migrants. Okay, so I want to completely uplift this tremendous article. This is by far the most comprehensive and developed theoretical legal scholarship on abolition in the immigration context. This is Angelica Chaparro's article, The End of Deportation, which introduces the concept of the common sense of deportation, the presumption that some level of deportation is inevitable. Built into this common sense is the assumption that a functioning immigration system requires deportation, because if you're going to admit some people lawfully, then you have to demonstrate your power to expel, as well as the assumption that saving the deserving immigrants from deportation presumes the continuing deportation of others. Building on the work of Allegra McLeod, Cesar Fatima Garcia Hernandez, and Amna Akbar, Chazaro also points to the Mi Gente Free Our Future platform, notes that he was actually the primary drafter of this document, and explains that it arose from efforts in the summer of 2018 to flesh out the emerging demand to abolish ICE. According to Chazaro, the platform models allegiance to those already territorially present, those on their way, and those yet to come, refusing the arbitrary geographic and temporal restrictions that underlie the common sense of deportation. Chazaro argues that against the image of immigration as being centrally concerned with membership and belonging, immigration law is deportation law. So that rather than concentric circles of membership that are typically drawn to represent a chronological or procedural continuum of the outsider seeking a visa with citizenship as the goal, a better model would be two circles, US citizens via birth and everybody else. Second, the article insists that deportation is violence. Violence is central to deportation. Addressing deportation requires inserting violence into the debate as defined by Ruthie Gilmore's cause of premature deaths, or in considering the specific subset of people tasked with this violence work, in the words of Nicole Siegel. The violence is hidden in plain sight, as in the case with prisons, taken for granted, taken as disconnected from most lives, and masked through euphemisms, punctured historically only with the outcry over family separation. The violence of deportation, writes Chesero, is not an aberration, but a defining feature and its ultimate purpose. So she asks, if deportation is illegitimate state violence coded as legitimate, the question becomes, what purpose does deportation serve? So deportation is alternatively posited as either extended border control or post-entry social control to control for safety and security. In terms of the latter, she says crime is an unstable category. Because of this instability, deportation is distributed in race-specific ways, specifically primarily through anti-Blackness, and is not based on conduct. As a result, he said we need to challenge all forms of banishment, which includes different forms of expulsion from society. In terms of the former of extended border control, deportation abolition needs to contend with the question of sovereignty. So finally, an author is addressing the question of the border. So sovereignty as a defense of deportation hides histories that led to the current maldistribution of resources at the heart of modern migration patterns in two ways. First, the nation state is currently configured as taken for granted and presumed to yield an unquestioned sovereignty, denying the history and present day challenges of indigenous peoples. Secondly, the US has repeatedly violated the sovereignty of other nations. Why should the US sovereignty remain sacrosanct as expressed through deportation? So here, Chesero points to the important work of Tendai Achume, who insists we think about migration as decolonization. Achume contends that corrective distributive justice considerations give third world migrants entitlements to national admission and inclusion in the first world as bound in a relationship of co-sovereignty due to neo-colonial interconnection. In addition, Chesero notes the incoherence of US borders and the ways the US operates outside its borders with externalization, interdiction, external migration control, obscuring the unjust advantages the US enjoys as an imperial power. And finally, she turns to ways we can end deportation in practice, criticizing law reform proposals that say deportation is illegitimate only because it's happening in the wrong way. In contrast to collective demands that refuse to assign value to life based on potential social contributions. And as an example, she points to Chicago's project Erase the Database campaign, which shrank surveillance by stopping the state's ability to track or label people as gang members and then deport them. So she does place the question of the ideal function of national borders in the 21st century as beyond the scope of the article. Okay, while suggesting that a debate on whether the nation state survives an encounter with limits to its exclusion and expulsion powers can only become possible after deportation is no longer taken for granted. So one could argue this is a case of chicken and egg, right? So it's like she wants to get rid of deportation and then turn to this question. Part of the task of thinking about this is taken up by Shirley Munshi and another helpful recent work of legal scholarship called Unsettling the Border. So part of what I'm trying to do here is uplift what I think are really wonderful recent scholarship in the legal realm that people, in other fields might find helpful and should know about. While not addressing the ideal function of national borders or whether they should be open, Munshi is trying to do what she calls a precursory role to unsettle borders, to defamiliarize, disenchant, and recontextualize borders through critically examining historical processes, legal developments, and the intellectual and discursive formations that naturalize and legitimize. So she defamiliarizes the border by resituating it within a broader imperial formation, recalling histories of conquest and expansion, and acknowledging indigenous priority. flipping around the conception of unauthorized migration as a problem to be solved, a crisis. She argues the nation state is actually the problem, right? So the nation state is only confronted by unauthorized migration as a crisis because it is confronted with the essential instability of our world order in which borders preserve and exploit inequalities. She concludes with the discussion of alternative sources of political agency and authority, the migrant caravan, and convergence among indigenous and immigrant activists. This is the last work that I want to share with you. So directly addressing the question of the existence of borders is this manifesto that came out in 2018 by the California Immigrant Youth Justice Alliance called First We Abolish ICE. It acknowledges we sit on occupied lands, that ICE and detention centers exist as an extension of the carceral state, and that prisons need to end along with global capitalism. In the conclusion, there's this passage essentially, which I read as saying we need to abolish borders, in saying that this needs to be a movement that is stateless and that they are against the idea of nationalism. So we might ask, why is this anomalous, right? And all of this literature and these reactions to the idea of abolition in the immigration context, right? Why is there this focus on abolish ICE? Well, I have these hypotheses, right? Is it about a hierarchy, right? Which places people who are already territorially present above those who are seeking to enter? Is it that there's greater reluctance to critique the coincidence of immigration enforcement with nation-state border control than with how we think about immigration power as about the police power in the interior? Is it about the synergy of abolitionist movements against prisons and police that align more with the abolition of immigration prisons, known as immigration detention, and with ICE, right? Rather than feeling there's not a natural synergy between abolish police, abolish prisons with abolish borders. Is it because it's easier to challenge deportations than to challenge the ability of the nation state to control a border or to have a border, right? So these latter two ideas, I think, are relatively self-explanatory, but I want to try to say more about the first two of these ideas. In terms of the first hypothesis, I turn to Linda Bosniak's idea of ethical territoriality, which is, quote, the conviction that rights and recognition should extend to all persons who are territorially present within the geographic space of a national state, simply by virtue of that presence. And this, you can see this conviction as manifest in many ways on the US legal landscape. The US constitutional framework protects persons in the territory. The rights non-citizens can enjoy is governed by the legacy of a Supreme Court case called Woe versus Hopkins, which arose in the context of San Francisco and like were permits being given to people operating laundries in wooden buildings and denying those permits primarily to people who were Chinese. And these were called persons, even though they're aliens, and saying that this 14th Amendment protection extends to them. So the rights non-citizens can enjoy is governed by this legacy in which the Supreme Court held that all persons within the territorial jurisdiction of the United States, no matter their immigration status, are persons for the purposes of the 14th Amendment, which constrains the ability of states to act against persons. The Fifth Amendment constrains the ability of the federal government. Okay. In many realms, non-citizens are entitled to be treated as any other person, regardless of their citizenship status. That immigrants enjoy this kind of territorial personhood may reflect the idea that they can enjoy the soft inside of the nation state, somewhat insulated from the hard outside of border regulation. In terms of that hard outside, procedural due process rights adhere to deportation proceedings brought against persons who historically were in the United States after 1996 to get to be put in removal on grounds of deportation. You have to be in and admitted, like lawfully admitted. And those procedural due process rights do not adhere to persons who are outside or who are in and not admitted. Okay, in other words, you entered without inspection. These lines are also muddy, right? The hard outside obviously follows the person into the soft inside in terms of their vulnerability to deportation. And immigration law is also this legal fiction, world of legal fiction. It's very Alice in Wonderland. You're situated physically in relationship to territory that may have no bearing to how you're legally situated. You can be physically inside, you're treated as if you're outside. You can be actually outside, but you're treated as if you're inside if you have this elevated status of being a lawful permanent resident who's only made a brief departure, for example. People who are paroled into the United States, and I don't know if you've seen that term, it's like not like parole in the criminal context, it's the way the government says we'll administratively allow you to be inside, but we're not treating you as if you're admitted. They are functionally, legally treated as if they're outside the United States in terms of the immigration rights that they have. I also want to pause and note that the designation of foreignness or non-belonging is not necessarily a function of coming from the territorial outside. It's also a political strategy that has been used historically both inside and outside the United States against various groups and for diverse purposes. So there are lots of ways in which people who are African American, people who are Native American, Indigenous, right, have been physically inside but are treated as foreign or outside. The idea of ethical territoriality clearly seems to be animating the greater ease with which scholars and activists call for abolition of ICE or deportation rather than of border enforcement. So that somebody's already here is presumed to give them a greater affinity, affiliation, contribution, state, or tie, rather than someone on the other side of the border, assuming the person is not a returning resident or has some other claim. This Migrant Justice Platform, which is this really fascinating document written by this Blue Ribbon Commission, this mix of NGO activists, farm workers, youth advocates, lawyers, where they essentially were trying to write a document for the Biden administration saying like, this is our vision, actually replicates some of this ethical territoriality, where they say, we're rooting our charge in the perspective of communities already living and working across the United States, which is the social position from which they render their critique, right? So immigrants yet to come are deserving of solidarity and human rights. They share a linked fate. They're future beneficiaries of particular programs, but nowhere is there an explicit call for free movement across borders or the abolition of nation-state borders. So in trying to puzzle this out, looking at this platform, it basically talks about how much our political representatives have not done, right? And when you look carefully at it, you can see that everything in the platform is actually a change that can happen within our current legal framework, right? So there's a quite pragmatic underpinning of the platform, which is narrowing what it can imagine, but also is fueling its demand, right? These are our political representatives. So the we, the people of this platform is still circumscribed by the nation state, right? So being here is producing we, the people, regardless of status, but then saying it's those who are here. So Linda Bosniak has a normative premise in her work on ethical territoriality, which is that territorial presence is a more desirable basis on which to grant rights than status, right? So you're a lawful permanent resident, you're a temporary visitor, you're undocumented, right? So I would certainly agree. But we quickly approach the issue that ethical territoriality seems to presuppose the existence of borders around the territory in question, raising why do we privilege someone who happens to be on the inside versus the outside, right? So here's a second idea. Is there greater comfort criticizing immigration enforcement and or calling for abolition when it is perceived to be a matter of police power than when it is perceived to be a matter of foreign power and national identity? And as a corollary, is immigration enforcement associated with ICE and deportation understood to be the former, while the patrolling of the border by Customs and Border Patrol seen as the latter? So this association, this division, of course, assumes away all this kind of muddying of inside and outside that I shared that exists in actuality. And in addition, right, both of these entities, CBP and ICE, are doing enforcement, removal, imprisonment. Both should be seen as equally about policing and prisons. Both should be seen as equally about foreign policy and national identity, right? Both are treating non-citizens as agents of their foreign governments, whether friendly aliens or enemy aliens, in the words of Supreme Court, sort of the first Supreme Court decision governing all this, the Chinese exclusion case, referring to vast hordes of people crowding in upon us. These, but when the target of enforcement is someone with no historic tie to the United States arriving for the first time, or is someone who's lived inside the United States for 50 years, is this enforcement understood as similar or is motivated by different state impulses? Is one legitimate patrolling of strangers who do not presumptively belong inside the nation state versus the illegitimate patrolling of neighbors who do? In puzzling this out, it's important to further unpack what is meant by the police power. So police power is the name 19th century jurists gave to the powers of a state legislature to pass laws in the more general interest of public safety, health, comfort, or order of morals and welfare. Police power has this open-ended, almost unbounded quality and was related to a capacious and nearly unlimitable conception of necessitous governance. In colonial and early US history, states and colonies engaged in immigration regulation to control the movement of persons into their borders and arose from police powers over health, welfare, and crime. The federal government's first forays into immigration control arose from concerns with foreign relations and the movement of non-citizens across international borders. So this concurrent state and federal jurisdiction over immigration arising from different powers ended in the late 1800s when the Supreme Court began to develop the concept of plenary power, that profound discretion is entrusted to the political branches, the executive and the legislature, over immigration, with very limited constitutionally imposed judicial restraints over immigration. This wide scope of the federal power over immigration preempted state action until the 1980s, when federal immigration law evolved from a stepchild of foreign policy, to the words of Juliet Stump, a comprehensive legislative and regulatory scheme that intersects the triumvirate of state power, criminal law, employment law, and welfare. So this shifting of seeing immigration law as about international foreign policy versus a more direct connection with crime, employment, and welfare casts immigration into a world infused with state regulation, especially for state and local efforts to engage in immigration law, right? Transforming immigration law from something the federal government is uniquely competent to control, which is foreign policy, to something that the states are expert in, which is law enforcement, right? And so this shifting was accompanied by, as you probably know, like this effort of localities to try to control immigrants, non-citizens, especially undocumented immigrants, states, very famously at 1070 in Arizona, et cetera. And there's sort of this pushback, like, can they do this? How much can they do this? How much of this is actually the federal government to do? What can the state do, et cetera? Another way to phrase this, and I'm almost concluding, another way to phrase this is the divergence between what are considered to be the core aspects of immigration, the admission and removal of non-citizens, and laws that govern the lives of non-citizens in their everyday life. So the former is called immigration law, and the latter is called alienage law. They're imagined to be these two disconnected spheres, where the former is the province of federal action, animated by international relations, and the other it could be federal action, it could be state action, and it's animated by police power. So alienage law would be what governs. Can a state deny welfare benefits to this group of people because they're lawful permanent residents? Can the state of Texas deny undocumented children public education, right? That's alienage law. Okay, immigration law is like your exclusion, your deportation, your admission. So they're seen as disconnected, but they obviously connect. For example, the immigration law says you can be denied admission because we think you're likely to become a public charge, meaning you're going to be financially reliant on the US government for certain kinds of cash assistance programs, or you can be deported because you relied on these programs, right? That's also about alienage law in terms of what kinds of benefits you have, how the government is regulating your everyday life outside of the context of immigration and exclusion. Nonetheless, assuming this kind of legal fiction, right, is too clear, and that there's a distinction drawn between non-citizens subject to removal based upon deportability versus inadmissibility, so deportation versus exclusion, right, that aligns with the sense of different powers of immigration. The former police power, which is seen as interior, the latter sovereignty, which is seen about the border, with one of these being about immigration law, and the other being about alienage, right? Is it possible that this could help explain the move to so quickly make the call to abolish ICE versus abolish CBP, right? Are people more reluctant to question the national boundary line drawing functions of the nation state than to question what is perceived to be policing of them? Okay, so those are my questions for you, and I look forward to discussing, and then I thought I would end with some images that show different ways that abolish ICE is articulated, accompanied by other demands, which I think is really interesting. So I will end there. Thank you.